CO2 emissions from automobiles pose a danger or they do not, or that the scientific uncertainty is so profound that EPA can't come to a reasoned determination on this issue. And the agency, the court says, did neither thing here. Now, it's important that the court does not require that EPA find endangerment and therefore trigger the regulatory requirements. But its opening assertion that greenhouse gases are causing climate change makes pretty obvious its view that the science supports an endangerment finding. The court barely disguises its frustration with an agency that has refused to address what the court views as a serious risk in the face of a statutory provision that mandates, the language is shall, agency regulation of emissions that are found to endanger. Now, it's that frustration, born of the court's sense of injury, that Justice Scalia hones in on in his dissent on these merits issues. He finds in the definition of air pollutant sufficient ambiguity to defer to the agency's determination, i.e. the determination that there's no authority. And similarly, he finds nothing in the statute that requires the administrator to make a judgment on endangerment or that limits what EPA may consider in deciding to defer making a judgment. Scalia ends his dissent with a coda that captures the tension between environmentalism and institutional restraint that I think is the organizing theme of the entire case. And I'm going to read it just because it's such a nice summary of this theme. This is Justice Scalia, I'm quoting, "The court's alarm over global warming may or may not be justified." He's not taking a position, expressing some skepticism, "but it ought not to distort the outcome of this litigation. This is a straightforward administrative law case in which Congress has passed a malleable statute giving broad discretion not to us, the court, but to an executive agency." Now, it's not obvious to me what effect Massachusetts v. EPA will have on EPA. The court has remanded the matter for further consideration by the agency, but it has not dictated a result, and it has not set a specific time deadline by which the agency must act. EPA, for its part, has said it respects the court's opinion. It's good. But what else could it say? But it will take time to figure out how to implement this opinion, and we can imagine that it will take a long time, perhaps and likely through the end of the administration at least. But even if this or a future EPA did find endangerment, and thus accepted the obligation to regulate, it's not clear what extent, or to what extent, an effective national climate change program could be assembled from existing EPA authorities. Also, the statute doesn't provide for international arrangements that will certainly be necessary to deal effectively with climate change. So further action by Congress and the President will be necessary to have a comprehensive climate change policy. So the holding itself may be of limited utility in actually solving the climate change problem, which brings me back to the symbolic significance of the opinion. The court has accepted, indeed it has seemed to internalize, the beliefs, assumptions, and values of the environmentalists on climate change. It has legitimized the environmentalist concerns against the efforts of the administration to discredit and put aside those concerns. The decision provides a rallying point now for climate change advocates and a touchstone for the public on this issue. I'm not saying that this is the Brown v. Board of Education for the environment, but it may be as close as we will ever come. There remain the dissenters' claims that the court has exceeded its institutional bounds and stepped into a policy role for which it is unsuited. Commentators will disagree on whether the court got this case right or not, but I don't think the court has usurped the agency's role. The court did what courts do. It marshaled the facts, it applied precedent, It interpreted statutory language. It stopped at least one step short of dictating policy. Indeed, if you read the remarks of EPA's administrator after the decision, the agency has lots of discretion left on what to do on remand. But the court did show its colors, and its colors were green. At this moment, that is the remarkable thing. Thank you.